long as until 2 o'clock. And then at that point, right around 2 o'clock Eastern, top of the hour, we'll have some time in breakout rooms where you'll have a chance to talk with other friends who are in situations similar to yours, people in similarly sized meetings or institutions, and reflect on what you've heard and do some work of, finding what is useful and sharing ideas. So that's the basic structure of today. And at that, I'm going to go ahead and turn the time over to our friend Dawn, and with my thanks.
Thank you, Emily. And I'm going to share screen. And hopefully you can see that and hear me. If not, Emily will let me know, correct?
I sure will, and you haven't shared screen yet.
Well, let me go back then. It says host disabled participant screen sharing on my screen.
Katrina, that's your cue. We're going to need to make Dawn a co-host.
So I'll try again. Still showing up.
Now you're the co-host. I just saw the notification come up. So try one more time.
Yes, ma'am, it's working.
Great.
And I think if you can remove the images of participants from the right-hand side of the screen, it'll make it more convenient for everyone.
I think that most of us are seeing this okay.
Okay.
And if anyone is not, I invite you to put your Zoom window into full screen, and that will help you considerably if you're having trouble. And Dawn, please go ahead.
Okay. It is the case that you still show up and a couple of others on my screen. Okay. So just for clarity, Emily approached me as, quote, an expert. I have clearly defined to her, I am not an expert. I am a non-lawyer. And this is based strictly on my experiences and the things I was led to do because of the roles that I had at the time. Those experiences really centered around a time when I was asked to be interim superintendent of North Carolina yearly meeting, when the yearly meeting was going through a time of transition. Ultimately, it resulted in my serving those 3 years and then 5 years as the board chair for the reorganized North Carolina yearly meeting. That reorganization moved us from an unincorporated association to 3 corporations, 3 LLCs, an unaffiliated group, and so many aspects to that we will review very briefly, but give you a sense of what can be accomplished. More recently, have been involved with the what decision we should make as Marlboro meeting, the meeting I attend here in North Carolina, what we should do regarding our personal situation with either incorporating or another option that I will review as the initial portion of this program. My background, I'll just say my last 15 years was involved particularly with the manufacturing integration of several companies that our parent company purchased. It would be both evaluation and integration. And so I will say all of that work helped me significantly along the way as well. The last note on this slide is important for all of us. Assure you have adequate insurance. You and your provider need to make certain whatever adequate is, that you have put that in place both for your directors and officers as well as from the liability insurance perspective. Again, I would emphasize that because regardless of what we do, we can still be sued under the right set of circumstances. So just paraphrasing the content of this meeting, what legal structures are available to us, what best serves us. Do I really need to pursue a letter of determination to formalize my 501c3 status? Are there situations where we should consider being an umbrella for other groups? So I put in a few things here that you probably have reviewed, but just in case, and there'll be a part of this as a reference if you need it. A church is not defined by the IRS. They give you a series of characteristics. These characteristics are not required in total, but some combination of them need to be readily apparent in order to qualify as a, quote, church. And this idea of distinct legal existence, for many, that's what led to incorporation, because that was their way to be defined as an entity. More recently, there is the Uniform Unincorporated Nonprofit Association Act that lets you achieve that status in many states without incorporating. They talk about a recognized creed and form of worship. As we know, Quakers are non-creedal, but there is certainly a form of worship that historically we can reflect on. Our faith and practice would reflect a form of government. Formal code of doctrine and discipline would again refer to faith and practice. Many of our faith and practices also include quite a bit of religious history. This list goes on. They talk about ordained ministers. Ours would be recorded, but the content is there for you to clearly see that you are a church, and there won't be any particular pushback on that from anyone as you pursue this. Do note in this last line that this includes all the administrative agencies of the church, including the cemeteries, any religious orders. We'll talk about integrated auxiliaries in a few minutes, which is something else that's included. Then the IRS may at some point wish to audit a church, but they have to do that on the basis of a reasonable belief that there is a problem with the particular entity. And this would spell out where they can secure the information that would allow them to form the basis for that conclusion. I would just note in the very last sentence on this slide, failure of the church to respond is a factor in determining if there's reasonable cause for commencing a church tax inquiry. So if you hear from the feds, answer the feds. Do not make this a part of the issue. So in North Carolina, particularly, there's a lot of emphasis on property tax. And in North Carolina, and I suppose in some other states, but again, you need to check your state. If you have property that your meeting owns and it's not using it for any purpose, it's taxable. If you have it and you're not using it for a religious or church-related program, it's likely taxable. If you are using it for a church-related program, there needs to be clear evidence and documentation that it is church-related. And in particular, this would be things like for Marlboro meeting. We have some acreage that has a series of trails through it, particularly for our youth and so on, and they are clearly marked and they show some wear and tear and all that kind of thing. So you want to do things that make it abundantly clear, and we'll come back to this in a moment with a fairly recent court finding in this. And then if you're leasing this to a non-church entity, it is taxable. So again, know you've got those property tax liabilities. In particular, I want to reflect on this decision by the Superior Court in Wisconsin, where they overturned the tax exemption for unemployment tax. It was done in 23, but this was just in the headlines last week, at least here in North Carolina. And basically, Catholic Charities were caring for older, disabled people that didn't have the means or the ability to care for themselves. And they concluded that while the work was being done based on Catholic teachings, the actual work was secular. The services were exactly the same as if they were coming from a secular provider. They were not operating with the purpose of sharing/spreading their faith. They note that the outcome might have been different if the church had been the actual employer of these persons. This is one of the things we have to be careful of as we break down our church group into multiple entities, because we may distance ourselves or distance a subset of ourselves as employees of another entity. So just a caution there. And then they go on to conclude that there is no attempt nor any actual program that participants in this care of the elderly, the seniors, where they attempt to share the Catholic faith or supply any religious materials. So that in some significant part led to the decision that this was secular work and that it was therefore, it required unemployment tax. This is a significant issue because think about the hospitals and other groups that all fall under this umbrella. And if it gets spread state to state, will have a significant impact. So of the several choices available, what legal structure should we utilize? So we can either use Occam's razor or maybe even Quaker simplicity to decide what we're going to explore. So Occam's razor essentially says the simplest solution is most often the best solution. If you have two competing ideas to explain the same phenomenon, you should prefer the simpler one. Or on average, the simplest solution is most likely to be correct. Notice all those have an outlet to say, but not always. So don't get hung up on that. But as Quakers, we know simplicity is often the case. So as you look at the pros and cons of incorporation, most attorneys are going to take you down the path of incorporation to protect yourself. And I'll talk about that further when we look at North Carolina Yearly Meeting Incorporated and how that came to pass. But there is an alternative available in many states, and that is the Uniform Unincorporated Nonprofit Association Act that extends many of the protections of incorporation to these unincorporated nonprofits as they go forward with their work. This was first proposed in 1996 and was actually amended in 2011. Every state has their own approach. Some states have adopted what was recommended that we're going to take a look at in just a moment. They've adopted it intact. Others have modified it somewhat. Others have incorporated aspects that offer opportunities for, I'll say, similar protections. It just won't necessarily be called the Uniform Unincorporated Nonprofit Act. So this Uniform Law Commission is a group of attorneys that are invited to share regarding areas of law that should be uniform from state to state, so that there isn't all this myriad of laws and approaches that come into play. They can only propose, the legislature has to adopt it. They do this as pro bono work. There are no salaries, no fees. It in fact costs them work in the big picture, but what's more important is it gives consistency state to state. Again, proposed in 96, modified in 2011. I suggest you see what your state might have done in this area. This would reflect the states that have adopted And you see that some of them had adopted the 96 version, some of them adopted the 2011 version. I can add now that South Carolina has adopted and Ohio has adopted. There might be others that would have again adopted in part or done their own spin, incorporating the principles of the act, if you will, as I'll kind of try to use that expression. I would point out that much of what I'm going to share today, not because I pursued it this way, it was an observation after the fact between the articles that support this coming from North Carolina, Pennsylvania, and Iowa. They all have something in common. They've all had significant Quaker populations at different times. And I don't know if that plays a role or it's happenstance, but it certainly kind of intrigued me as I saw that. So in North Carolina, this is their adoption, and we adopted this Uniform Unincorporated Nonprofit Association Act intact. And so what it does that most meetings, churches, nonprofits are concerned with is protect the individual from personal liability. In general, in times past, an unincorporated nonprofit association was treated as a partnership, and all the members of that nonprofit were equally liable. So there's this issue then that the lawyers, the Uniform Law Group, was trying to rectify. And again, you're going to see there are about 3 or 4 versions here that say essentially the same thing to a non-lawyer anyway. But what they're basically saying is, as a member, as a person that's referred to as a member, as a person that's a part of management of that unincorporated nonprofit, you are not personally liable unless you do certain things that would fall under the umbrella of illegal or fraudulent, etc. And we'll touch on that in a moment. Again, first element here is kind of a reiteration. Just again, my note, the veil of member protection. What we look for with a corporation, now we're looking for it from this act, if you will. If there's improper code, fraud, injustice to third parties, or other wrongdoing, just as in a corporation, I am still personally responsible. It's on me if I committed the act. I would encourage you to be very conscious that if you were to cite your faith and practice as being your operating manual for your business meetings, be sure you're adhering to your faith and practice, or you can make yourself vulnerable, particular to an internal dispute, perhaps external, but certainly from the internal perspective. So again, whatever you say you do, be sure you do it. They call it integrity, right? Isn't that one of those things we're supposed to know about? Okay, I'll move on. So this is an opinion that was written in 2007, right after the law was adopted in North Carolina, by a Quaker attorney residing in Greensboro. He was the managing partner of Brooks Pierce. He was also chair of Guilford College's Board of Trustees from 24 to 21, chair emeritus currently. Guy, from my perspective, is a person, I know him from a distance. I've been in meetings with him, but I don't really know him personally. But he has a great degree of expertise. Warpy, not a word in my vocabulary, but from the urban dictionary, it basically means clumsy or uncoordinated. So previously, unincorporated associations were not even recognized as entities. So now, just like the churches aren't well defined, these unincorporated associations are not well defined either. But as is stated by this attorney, they're no longer airy things either. But notice, and I've highlighted these, no one is required to do anything or change any procedures, because if you've been functioning in North Carolina and many of these other states as a nonprofit unincorporated association, then you are protected by this. So again, you don't have to do anything. Goes on to say there are no registration or filing requirements to pay, no mandatory form of organization, no rules, none of that stuff that you are required to do for incorporation. However, it does not address internal operation. Now, you know that your faith and practice would do that. You might adopt that, as we'll see in a moment, as your guide for business meetings, etc. So this act addresses property and the fact that the entity can own the property as opposed to trustees owning property. It speaks to the liability, which is often the driver for these considerations. It indeed allows the entity to be sued as opposed to the members being sued. If the nonprofit association were to be laid down, were to cease to exist, it lays out the proper procedure for disposing of their properties, which is very, very similar to the procedure for an incorporation. And an agent for service of process is absolutely voluntary, but it allows you to register a person who can receive notice if there is an issue, or more importantly, notice if there is a change in the law that may have significant impact on any one of us as a nonprofit association. And again, I'm still reading from the Warpy fella. He notes that many unincorporated associations like to have trappings of a corporation, charters, bylaws, rules of governance, etc. Notice again, none of these are required, and no requirement for anything in writing, in fact. But then there is this intimation, and this is kind of my note, that these things would be helpful if they're documented and adhered to. If they're not going to be adhered to, don't write them down. It'll just create a greater issue for you. And so, again, this all concludes with this idea of personal liability. One more time, they talk about this is to address external relations only, not to address internal procedures. And where there are internal issues, this would be resolved by general principles of law. But just think about it for a moment. If you have internal issues in a corporation, yes, there are certain things that are defined to be a part of the process, such as mediation, et cetera, et cetera. But then you can still go to the courts and look for legal principles to be equitably applied. I'll fast forward a little bit here. Members can sue the association just like you sue a corporation. The association may sue members. Again, all this would be where there is internal disagreement about the business practices or the operating of the entity. And then the last point on this page, you can, if you wish, have an agent file with the Secretary of State in North Carolina, and that would be true in many of the other states that have adopted. So this wraps up with the idea there's a new place for nonprofit associations, which is made available through this Unincorporated Nonprofit Association Act. It creates a choice so that you do not have to incorporate. You don't have to go through the expense of that. You don't have to go through all the nuances of that. And they actually conclude with a statement, or if you really don't necessarily want to be your existence to be made aware of. And we know there are entities out there like that. This is the form, one page in North Carolina to register as an unincorporated nonprofit association. You see it's a Baptist church in this case, but it might be a homeowners association, it might be athletic teams, it might be any number of things, but it is a way to receive any kind of process that's either served by state or by an individual filing suit. but it is also a way to receive information should there be a change in law. And the cost is $5 in order to make that registration with the state. And you see a link there that gets you to the North Carolina Secretary of State's office. Pennsylvania, their adoption included much of the same language as you see here. Drake University in Iowa, their law review, they just made several observations that I thought were very helpful. This was all drafted with the small, informal, nonprofit associations in mind, those that are likely to have no legal advice and so fail to make the considerations that a larger organization might make, including whether to incorporate, provide a solution for nonprofits that do not have access to an attorney, a viable option for attorneys to recommend to their smaller clients, particularly churches. And then they go on to say it's a desirable organizational form for a church that does not have the funds for the utilization of an attorney in an extensive manner. So again, a lot of this, forgive me, applies to us because of our size in many cases. In Colorado, there was a lawsuit where, again, Drake is citing this in their write-up, but they just note that in this particular lawsuit, if this act had not been passed in Colorado, then the members of the meeting would have been treated as partners in the unincorporated association and would have been individually liable for the outcome of this. And they just make the observation that the act has been shown to be effective in its application, in this case in Colorado. So again, Drake Law Review, Uniform Unincorporated Nonprofit Association Act, clearly the more efficient and simpler option, and they are citing between an LLC and the act, if you will, and it still provides that limited liability to members. Here, just again, making the point, driving home the point that to afford protection, you either need to address this via this act or incorporation or an LLC. And again, some of the states will say an association should have its own articles of association. Some encourage it, some require it, some don't speak to it at all. But what they suggest is take the IRS language that you see in this slide. And again, I know it's fine print, but in any case, if you substitute unincorporated nonprofit association or association, wherever you see corporation or incorporation, you could write your own articles of association, again, without embracing an attorney. These are some websites that are associated with this first group of entities, slides, etc., if you will. And I had put a break in here. I don't know how I'm doing on time. I need to keep rolling, I see, so I will. So incorporation, I see the thumbs up. Thank you. So there was a fellow named Gary North writing in 1984. And he took the position that incorporation was effectively immoral, that it in effect displaced the responsibility from any Christian, any person, to a corporation that would lead us to be irresponsible because we weren't going to be held accountable for our actions. I will say, not necessarily that members in the past at our meeting had read that, but they knew the fears of church and state. And so until, I'm going to say, the last 10, 15 years, there really wasn't serious consideration of incorporation at Marlboro Friends meeting. if you can see the title here, you'll see a reference to the Reverend Falwell. That would be Jerry Falwell. In Virginia, it was not possible to incorporate a church until 2002. And that it was at the behest of Jerry Falwell and the ACLU. Now, originally, I put a little background here. The framers of the Constitution didn't want anybody deciding which religious institutions would be allowed to be incorporated and which ones would not. So it was a part of that separation of church and state, or religious freedom. Then the ACLU notes the old law placed in modern context discriminates against religious institutions, but not by denying them the same opportunity to incorporate. Well, we all know Falwell and the ACLU succeeded in the suit. They can now incorporate, but this is all related to the expansion of the school and the properties, et cetera, that were a part of, we'll say, the Falwell network. So again, I won't read all of this, but I had a contact in 2017 from a member of a meeting that said, and he was associated with a law firm, but was not a lawyer. And he knew that there had been a statute that created some liability protection for unincorporated entities. He was asking with regard to his meeting and our trustees of trust funds. And so I emailed our attorney saying, what about this? What's its applicability, et cetera, et cetera. And you see in the lower half of this slide, his response. It does offer limited liability protection against third-party suits, North Carolina Nonprofit Corporation Act. However, in my opinion, it's not as robust as incorporation. So this all kind of hung on how robust do we need to be. North Carolina Yearly Meeting decided that they would proceed with incorporation. Not that there's a huge sum or properties or whatever, but it is significant. And it was deemed that those protections, greater robustness were needed. And it is reiterated by our attorney at that time that statute, meaning the Nonprofit Act, offers little guidance regarding internal governance, etc. But he says, I rarely use it for use the form for planning purposes, but will often rely on it for defensive purposes. So he knew he could take a strong position for his clients that hadn't incorporated using this act because it had been adopted by North Carolina in 2007. So this was the structure that was put in place with the reorganization of North Carolina Yearly Meeting. The two gray blocks, upper left, upper right, are the two associations of meetings, the two yearly meetings, in fact, today. The blue box in the center is NCYM Inc., which is an integrated auxiliary of those two entities. And then you see below NCYM Inc., 3 LLCs. NCYM Inc. is the single member of each of those entities. And then you'll see in a little green box down toward the bottom, the Quaker Lake Camp Foundation, which is independent of and not under the umbrella of these other entities. I put this in just to show how responsibilities are assigned in these various elements. Don't know that I need to spend any time there. Glad to share contact information if people want to know anything about this. So this process of incorporation, you'll need your articles of incorporation, you'll need bylaws. There will need to be a contribution agreement or a merger agreement that will take the properties of the unincorporated association to either the unincorporated nonprofit association under the law or to the corporation. Then there are resolutions that have to be passed by the unincorporated association, and then board resolutions at the initial meeting. So frankly, it's a lot of boilerplate and a lot of paperwork. everything you see on this page is boilerplate. It is taken directly from the IRS code and copied and pasted from my perspective. Although I took it out of what we received, it's consistent with the page with all the fine print in terms of the purposes and so forth. But it's the language the IRS uses, and you'll see one of the documents in here cites the magic wording of the IRS. So that's what's reflected here. I do need to go back. Notice here, I did include the part, no part of the activities shall be carrying on a propaganda or otherwise attempting to influence legislation. You'll note that FCNL does attempt to influence legislation. Therefore, those gifts to FCNL are not tax deductible. You also know there's an educational branch to FCNL. This is a copy of their statement regarding how you might make your contributions when you experience a benefit and when you don't experience a benefit, etc. Again, this is all boilerplate. It just clarifies, and it, in effect, this first one, no part of the net earnings of NCYM shall inure to any of those directors, trustees, etc. One of those places you can get in trouble and you are not protected. You are susceptible to having the veil of protection pierced if you engage in any of that. And then within this, again, there's some boilerplate here. Trustees shall not be personally liable. And it goes on to name those instances unless you do these things that you knew or believed were in conflict, that you took loans from or made loans to other trustees, received an improper benefit, and unless you did something before you incorporated, you would still be liable for that as an individual. Goes on to tell how this incorporation can be dissolved, and it's quite similar to what's been adopted for the Uniform Unincorporated Nonprofit Association Act. I get tired of saying that anyway. Then NCYM Inc. You'll notice it's incorporated as an integrated auxiliary of the French Church of North Carolina, North Carolina Nonprofit Corporation, North Carolina Fellowship of Friends, North Carolina Nonprofit Association. And again, it goes into kind of boilerplate language. They have the general powers conferred upon charitable, religious, corporate, and nonprofit corporations, etc. And integrated auxiliary is important because this is something, depending on how much you try to protect yourself, it's a way to set off groups. And I was totally unfamiliar with this until our attorney broached this back in 2017 as a way to accommodate some of the goals of the group without the conflict that had previously existed. Refers to a class of organizations related to a church or association of church, but are not such organizations themselves. And it gives you the requirements to qualify. But then notice, men's and women's organizations, seminaries, mission societies, youth groups, so on and so forth. So again, NCYM Inc. effectively became the business arm of the former NCYM, serving both yearly meetings, all three LLCs that grew out of this reorganization, the business arm. They are obviously not a church, but they are doing the work of the church in their work as the integrated auxiliary. This just clarifies automatically considered tax exempt if you are a church. You are not required to file an annual return. You are not subject to any kind of automatic revocation because you weren't required to file a return to begin with. A little bit about the structure of NCYM Inc. 6 members each from the 2 yearly meetings. This is where we work to achieve balance. Other places there isn't balance. Other places there's expertise. So depending on what the particular function of the LLC is, you would see these balances adjusted. So These LLCs basically have two voting members. They would be the two associations, Friends Church of North Carolina or North Carolina Fellowship of Friends. Those voting members, if you will, are represented by 6 trustees from each group, and each of those must be a member of that association. Manner of acting, I put this in only because there's some language here that we kind of struggle to get incorporated. This idea of sense of the meeting is not a legal term, but it was something that the lawyer incorporated in accordance with the practice of Friends to help with that understanding. Presumption of assent was incorporated, which we felt was important because if you're present and you don't speak up, you are understood to have approved the decision regardless of what goes on in the parking lot. So for an individual meeting, if you wanted to incorporate, and this is just a personal perspective, the board would be defined as the members of the meeting because all the members of the meeting are members of the monthly meeting. Perhaps a quorum of the board would be the members of the monthly meeting present at a regularly scheduled monthly meeting or appropriately scheduled call meeting. So again, it's the same thing we do now. It's equating it to terms that you would find in the law, however. Perhaps the manner of acting is per your faith and practice, but again, you want to make sure you have adherence to the faith and practice if you say that's how you act. And then perhaps if you incorporated, you could call the annual meeting, or you could name your review of your annual budget for the next year as your annual meeting, or when you approve your officers for the next year. All of those could fit into this idea of an annual meeting because all those things are required as a part of incorporation. Just some other stuff that I won't get into that you'll have to have in place for incorporation. Contribution agreement, I'm going to skip right over. It's almost self-explanatory. But then as you get into the LLCs, you'll see in particular with Quaker Lake Camp, we not only had the articles of organization, but we had an operating agreement and a lease agreement, and those things that I'll say control the physical plant and the programming to some degree. There's a lot of latitude, but there's also still the guidance, if you will, approval of NCYM Inc., which is composed equally of representation from the 2 yearly meetings. And again, a lot of detail here. I'm going to skip that. If you have interest, we can talk about it. Limited liability company, not the most common form for a church. This is where it says, be sure you got the magic language in there if you use the process. But others would say an LLC structure for a church is a poor choice. Normally, the church would be the tax exempt entity, and a single member LLC would be, much like you saw with the 3 LLCs we have, would be somewhat separate and apart from to protect, we shall say, one another. A little bit about the fees and reporting structure for an LLC. And when you talk about umbrella, you can effectively say that Quaker Lake Camp LLC, NCYM Funds LLC, and North Carolina Friends Disaster LLC are all under the umbrella of North Carolina Yearly Meeting Inc. North Carolina Yearly Meeting Inc. is the sole member of each of those. We can kind of go on down, and when we talk about tax IDs and separate identification, the NCYM Inc. and the 2 yearly meetings have their own EINs, tax IDs as corporations. Quaker Lake has both of those, has that as well, because they employ staff and they do have their own income. NCYM Funds, which is our investment group, they have their own ID basically to facilitate their work with investment firms. And then North Carolina Friends Disaster Service LLC operates under NCYM Inc.'s EIN, and and that's because we basically do all their business for them. They are a relatively small group that works. Would note that under Friends Disaster Service, we developed hold harmless agreements and waivers for volunteers. Again, a layer of protection that you want to be mindful of as you might have projects of any sort that you undertake. Quaker Lake Camp Foundation, they determined they wanted to have, that they needed to have their own separate 501c3. Again, I do this quick comparison here. They talk about a 501c3 with a formal letter of determination, exempt from paying federal income tax. Church already is. Sales and state tax exemptions already is as a church. Donors and grantors can claim the contributions, already is for a church. Encourages people to support their nonprofit with their donations. You can do that as a church. Last one's what's important. Apply to facilitate grants earmarked specifically for nonprofits. They're being able to say, we are standalone, we've got our number, this is what you need for your protection. That can be very beneficial. Some information here about the process for that standalone work, that it's all self-explanatory. As you consider this idea of establishing your own 501c3, just a series of things that you would likely want to be sure of, because in part we stumbled through these, and so there's some experience in these list of things, scars. And so this is us today. And I almost made it by 2 o'clock. I did make it by 2 o'clock. So Emily, it's up to you.
All right. So are we transitioning now into our small group period of time? Did you have one more piece, Don, or was that it? That was it, right?
That's it.